Stories-Lawyers of Reddit. What's your best, most I rest my case moment? Story 1. I was on the losing end of this one. I was representing a pro bono defendant who was attempting to regain custody of her children. The family division attorney was laying out his case to the judge for why my client wasn't ready, and his final point was that my client had refused emotional counseling to avoid violent fits of rage that she had inflicted on her children. On cue, my client jumps up screaming, "You judge lady, you is stupid. YLL for taking my kids, you cunts." I just caught the opposing attorney's smirk of satisfaction as I got up to usher my client out of the courtroom. Edit: in case you are feeling the slightest bit of sympathy for my client. Here is some more background. I was in law school. I had to argue a case for an exam. I was the last in my class to go, so there wasn't anyone arguing against me. I opened with a motion to dismiss since opposing had failed to show. The judge, grading me, chuckled and said, "Touche, counsel." I still had to go forward, but we got off on the right foot, and I ended up with an A. Story 2. Not a case-winning moment, but a motion-winning one for sure. Think of cases like a big conflict, with motion hearings as little conflicts. Opposing attorney was insisting that Rule A meant they could do X. I tried multiple times to point out Rule A literally did not say that. During the hearing, the judge reached behind them, grabbed their rules of civil procedure, basically a dictionary of rules, placed it in front of the other attorney, and said, "Show me where Rule A says X." Other attorney did not take the hint, read rules out loud for a brutal 5 minutes, and gave the book back. I said, "Judge, I have nothing to add." It was pretty fun. Story 3. Opposing counsel decided that I had coached my witness and gave him lines to repeat, that he was lying. Short version is that he asked the witness if he spoke to me before he testified. Witness said he had. Attorney looked like he thought he had me. Attorney asked the witness what I told him, what instructions I gave him. Witness looked him dead in the eye and said, "First thing he told me was to tell the truth no matter what. He said the lawyer is never the one who goes to jail, that he isn't going to jail for me. And if I lie, I'm on my own." Attorney looked like someone took the air out of him. Everyone in the courtroom simultaneously looked at me. Only time I've smirked or laughed in court, I wanted to put my feet up on the table like I was Vincent LaGuardia Gambini, hands behind my head, and say, "I'm done with this guy." Story 4. I was prosecuting some kid. He had an antisocial behavior order, which meant that he was not supposed to go to a certain street. He had pleaded not guilty on the basis that he had not been there. I opened my cross-examination by holding up a map and pointing at the street. I said to him, "You went here, didn't you?" He said, "Yes." In England, we don't say "I rest my case." Instead, I looked up at the bench, said no further questions, and sat down. It might not seem bad dash, but I got the defendant to admit the offense with one question. That never happens. Story 5. Corporate lawyer. So, I don't have cases to rest. But once opposing counsel was forcefully insisting that it was ridiculous for me to expect a certain provision in a contract we were negotiating, and I pointed out that this provision was standard in his own firm's contract forms, as I knew from several prior transactions ID worked on across from him. Pretty exciting stuff. He took it in stride and said jokingly, "Well, of course it's fine when we ask for it." Story 6. I represented a company that was sued for breach of contract by a former independent contractor. Dude basically alleged that my client wasn't paying him correctly in accordance with the contract. During his deposition, dude admits that he never reviewed any documents to make sure his allegations were true, never reviewed his complaint before filing it to make sure the allegations in it were true, and had no idea whether or not my client actually failed to pay him in accordance with the contract. Basically, he tells me that he was suing my client because he didn't think their agreement was fair even though he agreed to the terms when he signed the contract. The kicker is that he admitted that he owed my client money. At arbitration, he tries to flip his story and starts giving testimony that is the exact opposite of his DP. So I whip out his transcript and undermine his testimony bit by bit. Needless to say, I won that case. Story 7. Defendant in a bench trial for a speeding ticket said he couldn't possibly go as fast as the officer clocked him. He knew this because he videotaped himself accelerating from a full stop to the location of where the officer sat. His experiment showed his vehicle could only get to 55 miles per hour and not the 67 miles per hour he was clocked at. The ADA then moved to have another speeding ticket issued because the actual posted speed limit was 50 miles per hour. Story 8. SDS said, "Hear my wife and not me." And it was during sentencing. "Mr. Defendant, local gang boss, you stated you are not and have never been in a gang." "That's correct." "Do you have any tattoos?" "Yeah, I have a tiger on my calf and one on my chest that says GD for life." "What does GD stand for?" "Gangster Disciples." "But I mean..." "No further questions, you honor." Complaining witness accused my client of harassment stalking. Said she told him numerous times that she wanted nothing to do with him. My client claimed they were dating, but whenever she got mad at him, she'd call the police and say he was harassing her. On the stand, she testified that she had never dated him, never invited him into her home, wanted nothing to do with him. She presented a photo on her phone of him sitting on her porch to prove that he had come to her property. I asked the judge permission to look at the photos before and after the porch photo for context. Girl had dozens of photos of the guy, who was clearly her boyfriend. I showed her one such picture. This is Mr. So-and-so, right? Yes, in this photo, he's on a bed. Yes, the bed is yours. Yes, the bed is in your bedroom. Yes, you took this photo of him. Yes, he's smiling in the photo. Yes, and in this photo, he's wearing your brassiere. Yes, no further questions, Your Honor. Story 9, but I was in traffic court one time and saw a lawyer straight up murder a cop with words. The cop had previously testified that the weather on the night of the traffic stop was heavy rain and winds so strong that the defendant could only open his window 3, and that the car had stopped on an area with very little shoulder, forcing the cop to approach from the passenger side, not the driver's side. The cop had then testified that he smelled a strong smell of alcohol on the defendant's breath. When the defense lawyer got up, he repeated what the cop had said almost verbatim and asked how he could have possibly smelled alcohol on the breath of someone on the other side of the car through a 3 crack in the window on a night with pouring rain and strong winds. The cop sort of opened and shut his mouth a few times, squirmed around in his seat, and said, "That's just what I always write in my log, to remind me that it was a DUI stop." The judge threw the case out. No motion to dismiss needed. Then he took a break and called the traffic prosecutor and the cop in his office. I'm guessing it wasn't for a nice spot of tea and some scones. Edit really, people you've never seen Ianel in a comment thread before. Story 10, I'm relatively junior, so am hoping to beat this one day. I defend professionals and brought a motion to dismiss a case on the basis that the plaintiff could not prove my client was negligent as she had not served the required expert evidence. As opposing counsel and I waited for a motion to be heard, we were sitting in the courtroom. The judge, who I did not know and who had not read our materials, wanted to talk to the parties of a short trial, which was to be heard after our motion was argued. That matter was also a professional negligence matter, and the plaintiffs had no expert support. The judge then spent 10 minutes explaining that he had practiced in professional negligence for many years and was well versed in the evidentiary requirements to prove the elements of professional negligence. In fact, he said, I very rarely use the word impossible in this courtroom, but it is impossible for you to be successful without expert evidence. Our matter was then called, and I reveled in explaining to the judge that he was about to hear a motion to dismiss a professional negligence case on the basis that the plaintiff had no expert evidence. I won. Story 11, my sister got T-boned by a car, causing a concussion when I was younger. Long story short, we were in court with the judge, who asked the driver if he had ever sped before. No, Your Honor, I never speed, was his reply. The judge asked him a couple more times if he was sure if he never sped. Ever. The driver was adamant that he never sped and never had before. A few minutes later, my sister's lawyer gave the judge some paperwork. She read it and said to the driver, "It seems that you have some past driving violations. Can you tell me what they are for?" Speeding, the driver had to pay medical bills for my sister. Story 12, we had a case where opposing counsel was cross-examining our expert witness on hydrology regarding some silt runoff issues. Mr. Smith, wouldn't you agree that the book I'm holding is highly respected in your field and considered to be the gold standard on the subject? Witness, I am aware that it is highly regarded in my field. Would you be willing to explain, in your own words, what paragraph 6 to 10 on page 121 is describing? Witness reads the passage word for word. Yes, I can read, but could you put this passage in your own words for the court? Witness, these are my own words. I wrote it. We were the defendants. We were being sued by an HOA over silt in a lake. We were able to prove that we weren't responsible and prevailed. It actually originated from another site and entered the lake elsewhere. However, that site was owned by a very large corporation, and I don't think the HOA wanted to fight with an entity that could fight forever. Story 13, I do mostly solicitor work, so if I'm doing my job right, I don't get a whole lot of these type of moments. That being said, I had a long-time client who was being sued, and I got to shut down the guy suing him in a very satisfying way. So my client had hired a guy we will call Kevin as basically a right-hand man for his company. The employment contract wasn't done yet, but they had an agreement that Kevin would work 6 weeks at a lower wage and then sign the contract and get the agreed-upon wage. So the guy works decently for 5 weeks and then is given the contract to sign. He comes back to the owner, my client, and says that he has some small changes he would like to make. When the owner gets the contract back, he finds that the small changes involve removing the duties and responsibilities section, basically the job description and the non-competitive confidentiality clause. Not only that, but he has written in a higher salary than agreed and added a bunch of new benefits for himself. Obviously, my client tells him that he can either sign the contract as it was originally laid out or he could find himself another job. He takes the latter option, but he starts a lawsuit against the owner wanting to be paid for the 6 weeks he was supposed to work, which had already been paid, 2 weeks in lieu of notice and 5 weeks vacation pay. I got the enjoyable job of telling Kevin, in front of a judge, that he was not entitled to anything under the employment legislation, and the only way he could get any of that would be if he had signed the contract. Judge dismissed the case and awarded costs to the defendant, but not before giving Kevin a lecture on wasting the court's time. Story 14. IP lawyer. Deep in a set of terms and conditions on a website. Our client's details, name, and contact details were listed, so it is very evident that they just copy-pasted our client's legal terms and conditions and missed a couple of details they needed to change. I was handed the matter, did a quick Control-F for client details, and it was an open and shut case. Not really that impressive, but saved me hours of time going through each term one after the other, noting exact similarities for a letter of demand. Story 15. I saw another thread asking about this a while ago, and someone in their link to this, which I actually really liked, probably OP of the comment, Yugera Carol. Story 16. Not a lawyer, but during a particularly nasty employment mediation hearing, I got to ask my former employer a question about payments per employment law. Did you or did you not pay into state-mandated unemployment insurance fund for all your employees past and present? Silence mediator, sir. Answer the question, silence mediator. Well, let me ask it. Did you or did you not pay into state-mandated unemployment insurance fund for all your employees past and present? Silence mediator. I'll take that as a no. Story 17. As a young attorney, I had stated a claim that an insurance company was dragging out a case in bad faith. In hopes that my elderly client would die before they had to pay him, I was requesting that the trial date be given priority due to my client's advanced age. The judge was no spring chicken himself, and seemed skeptical when he asked exactly how old my client was, maybe thinking that he was in his 70s and must merely seem ancient to a baby lawyer like me. When I responded that my client was 92, and the case has already gone on for 5 years, the judge was visibly shocked and immediately granted my motion for priority, shutting down the insurance company's attorney's attempt to respond. They wrote us a check for $1 million the next week. Story 18. I was representing a woman with a severe neck injury. Opposing counsel presented a test result that showed her cervical exam was normal. I felt almost bad when I pointed out he had the wrong cervical area in mind. Story 19. I'm not a lawyer, but the most memorable court scene I witnessed was 1968, Sacramento, California. I was waiting to be tried in traffic court, my usual speeding before Earl Warren Jr., the son of the great Earl Warren of Supreme Court fame. The guy before me was being tried for reckless driving. When it got down to sentencing, Earl Warren Jr. ordered some nominal fine and that the defendant attend traffic school. The defendant got all upset and began ranting how he didn't need to go to traffic school. As the defendant slowed down, Earl Warren Jr. calmly stated, "Well, sir, I cannot make you attend traffic school. I can only issue the order for you to attend. If I find after 2 weeks you have not attended, I will issue a warrant for your arrest and place you in county jail for 30 days, at the end of which I will renew the order for you to attend traffic school. So we can keep you going in and out of jail until you decide to attend traffic school." The guy just grumbled and walked out of court. Don't know if he did go. I certainly did when I got a similar sentence. Story 20. It wasn't a trial, though we had one of those and I won it easily. Just always stuck with me because of how clearly the law supported my position to the point that it was inarguable otherwise, and also because of how ridiculous the claim of monetary damages was. Guy moved out of his apartment, turned in his keys, then came back 15 days later demanding access so that he could retrieve belongings that he had left behind, which at that point had been trashed. It was just some minor furniture-type items. Lampshade is the only thing I clearly remember, and a box of his college notebooks. Notes he took during class. He is furious and sues the landlord in small claims for $5,000 state maximum because his notebooks have such huge value apparently. They hire me, and I respond, which moves the case out of small claims. It's just the way it works here after time in legal advice. I know this is not the case for every state, but our rule is better than yours. But enough aside, this puts him at a huge disadvantage because now he can't rely on the lax rules of small claims. So he goes out and hires a lawyer. The lawyer calls me to try to talk settlement. I know her pretty well, so I wasn't rude or anything, but I kind of scoffed and was like, "No, that won't be happening," and direct her attention to a particular state statute, then read it out loud to her. This statute, unlike everything else in the law, isn't overly long or wordy or hard to follow. It just says bluntly that when someone actually moves out and gives notice of this, items left after 10 days are abandoned, period. In a story, I could feel her deflate on the phone and encourage her to dismiss the suit. She did not. We proceeded to a short bench trial in district court that we won. Story 21, terrible people had stolen all of this little old lattice money. They said it was a gift, but their only evidence was a document in the bad person's handwriting that was allegedly dictated. It said September 2012, no day, just the month. Clearly the rogue had forged that when she found out about the lawsuit and, not remembering when she had stolen it, she hoped if she could guess within the month no one could challenge her. So in questioning her about it, Exhibit B is the little old lattice bank record. Now that withdrawal at the bottom, is that the alleged gift? Yes. Can you read the date of that transaction for me? August 25th, 2012. Thank you. Story 22. I have two that I like to share. I'll apologize up front for the length of my response. The first involve a lawsuit against the owner of a Mexican restaurant for not paying his employees and keeping the waiters' tips. He was just a terrible, all-around guy. He created these fake handwritten schedules and payroll records going back years to try and prove that his employees didn't work but a few hours each week and were paid for what they did work. It was difficult to prove they were fakes, but we managed to trap him during his deposition. I made the guy go through random bits of his work schedule and asked him to confirm they were correct. We did a random week in February, March, April, then we got to May. So here in early May, you had 2 servers working every night, 1 hostess, 1 bartender, and 2 cooks. Yes, and that didn't fluctuate. You didn't have a need for extra staff on, say, weekend nights. No, it was very steady no matter the day. What about on this Wednesday? How much staff did you need? Just the 2 servers, my hostess, the bartender, and 2 cooks, the same as every other night. And if you would indulge me, what date are we looking at? May 5th, okay? So it's your testimony under oath that you had the same staffing needs on May the 5th as you did on May 4th and May 6th. Yeah. Opposing counsel's head begins to hang while shaking. So you're comfortable telling the judge you didn't do extra business on May 5th, yeah, or June 17th, or whatever date you pick. It was always steady. You have no problem walking into court and telling the judge and the jury, under oath, that your Mexican restaurant didn't need any extra help on May 5th, that these schedules and payroll records you've produced are 100 accurate. For Cinco de Mayo, you're totally comfortable with doing that. Yeah, I owe. The case settled within a week. Story 2, state law enforcement was trying to prosecute a local cop for accessing name and address information for an individual in the state's criminal justice computer system to help a friend who was a process server. The state was prosecuting the cop for violating the Computer Crimes Act, which in part makes it illegal to share any information which the state has an intellectual property interest in. We show up for trial, having waived our right to a jury, and allow the head of the Attorney General's litigation department to make this wonderfully colorful speech about a police officer breaking the public trust and this other nonsense. For our opening statement, we move to dismiss the indictment on the grounds that the state's theory of the case is a legal impossibility. The state cannot have an ownership interest in someone's name or address. The judge was annoyed with our tactic and put the screws to us by asking dozens of questions, but we kept repeating our theory the state cannot own a name or address as intellectual property. Finally, the judge gets it and turns to question the AG. He tries to dance his way out of answering the big question all sorts of ways. Eventually, the judge flat out asked him if he contends the state can own someone's name or address. The AG responded by saying, "Judge, I came here to try a case, not to argue the law." The judge was not impressed and dismissed the case immediately and wrote a letter to the Attorney General asking him to be more selective in his prosecutions. That was a fun day in court. Story 23, I helped the prosecution rest his case. LOL, I got jammed up during spring break doing dumb spring break. So there I was in court to face the music misdemeanors. As I sat there waiting for my turn, I watched person after person go before the judge. The prosecutor read their charges and some information from the police report, stating what the potential max sentence was for each. I don't remember exactly. Then the judge asked what plea they wanted to enter. Almost everyone said not guilty, and I could see that both the judge and prosecutor were getting tired of their bullshit. Finally, my turn came. I was probably second to last after what seemed like hours, but may not have been. The prosecutor read off my charges and cited the police report. The judge looked at me with this "let's just get out of the way, tell us you're not guilty" look, and asked how I pled. "Guilty, Your Honor." The judge and the prosecutor both looked at each other, and the judge said, "Kid, you not say again, or beg your pardon?" "Guilty, Your Honor, I did it, just the way Officer Suss report reads." They exchanged looks again, and the prosecutor held his papers at arm's length as if to get a better look at them, and did the unthinkable. "Your Honor, this all reads to me like a case of college prank gone bad. The county moves to reduce charges to XYZ. I walked in there expecting some jail time, and walked out paying like 110 plus costs. I didn't really know how to feel about the scariest day of my life turning into one of the happiest ones." Story 24, I once had an appeal where the precedent all from other circuit courts, was very bad for me. The circuit court I was arguing in front of had a decision that was very good for me, but it was unpublished, meaning that it was not precedential. My goal was to convince the court to follow its unpublished decision, not the decisions of the other circuits. During my argument, I cited the unpublished decision. One of the judges interrupts me and asks, "But wasn't that decision unpublished?" I answered yes, but it was well-reasoned. He replied with a self-effacing quip, "I was on the panel for that decision, so it couldn't have been that well-reasoned." The audience laughed a bit. I answered quickly, "In that case, Your Honor, it was at least well-written." The audience and all the judges burst into laughter. I ended up winning in a published decision, which turned the old unpublished decision into binding precedent. A bit of humor can go a long way in the courtroom, especially when you're flattering the judges. Story 25, I'm not an attorney, and it wasn't in front of a judge, but I got into a dispute with a contractor who up royally when installing a new heating system, resulting in an asbestos contamination of my house. Their insurance argued the contractor couldn't have caused the contamination, because the contamination was way worse than could have been possible from what the contractor did, which is bullshit. They argued the contamination must have been caused by the contractor that installed the previous heating system. It was super satisfying to write our response one. The previous heating system was placed 12 years earlier. The asbestos dust was visibly lying everywhere. Arguing we didn't vacuum for 12 years was beyond ridiculous. 2. The asbestos dust was on a floor we installed 6 months earlier, included the receipt for the floor. And then the third point was the most fun to write. 3. I said they were welcome to believe the contamination was caused by the contractor who installed the previous system 12 years ago. I included the receipt of that installation. It was done by the same contractor. The next letter was very brief, stating they would pay us for all damages we were claiming. Story 26, my client and his wife were woken up one night because people were trying to break in his house. He fired 2 warning shots as his wife called 911. The neighbor also called 911. When the police got the neighbor's call that there were shots fired, the police sergeant radioed the other officers and said he's going to jail tonight, referring to my client. So obviously, even with signs of someone trying to break in and his wife calling 911 for help, the officers arrest my client for endangering his wife by shooting inside the house, nowhere near her. It gets to a jury trial, and I start to go off on the police sergeant about why she would say that before an investigation and before she even had any idea what happened. The sergeant had no idea how to respond and literally just sat there staring at me for a solid 2 minutes before saying anything. Even the bailiffs were audibly laughing. Story 27, Ianel. And I've told this story before, but it always makes me smile. Wall of text incoming. I was in court to get more placement for my 2 kids. My ex-wife and her sister were claiming all sorts of things, that I was abusive and a stalker and a rapist, and on and on and on. Like, to give you an example of what they were pulling, they claimed that I choked my daughter, and then they brought her to the doctor in October 2016. The doctor brought in a second doctor, and they both looked at these marks on her neck, and were like, we can't exactly call the police for this because it's unclear. I pulled the doctor's records, and the appointment never even happened. So there were a few moments. One was that they were claiming that I angrily hauled my son out of their house because he wouldn't put on his shoes or coat in the wintertime. Now, while I did take him out of the house, it was because they had been arguing for 10 minutes with a 4-year-old about putting on shoes and a coat in winter. They had only gotten his shoes on, so I picked him up and took him to the car. Then he stopped me and wanted to put on his coat, so this was their big moment. He looked so angry and hauled son out of the house. My attorney has my ex's sister on the stand. She's already unsteady on the stand, muttering and not answering questions clearly, and trying to lie without lying. So my attorney asks, why did you think it was unnecessary for Bruce Lee 1255 to carry son out of the house? She says, because you can reason with son. He's 4. You really think you can reason with him? Yeah, so in this case, did it work? She froze, like literally froze for about 5 seconds. She didn't say a thing. 5 seconds doesn't sound like a lot, but when you're on the stand and everyone is staring at you, it's interminable. Finally, she said, well, it usually does, but in this case, did it work? Well, it usually does. He moved on, but the best part, and the one where I could have flown, was toward the end of the trial. So, my ex spent 8 hours spread out over days ripping apart my character. I was a rapist, an abuser, violent, but also one time I sent my daughter home with dog on her shoe. Murder, arson, and jaywalking is what we called it. Like, if he's so violent, why are you even complaining that one time she had dog on her shoe anyway? So, after all this time, she still never explained why she thought my daughter couldn't have more time with me. She made a lot of hints, but never nailed down any reasons in any communication she sent to me. Even in her deposition, she didn't say anything about abuse. So, finally my attorney nails her down on the last day, and she says that she's afraid that my daughter won't know that mommy's going to come back, Basically, that my daughter lacked object permanence. The judge asks her a few questions. He says, "So are your son and daughter close?" "Oh, yes, very close." "Does daughter miss him when he goes to school?" "Oh, yes, very much so." "So, does she miss him because she loves him or miss him because he's not coming back?" "Oh, she knows he's coming back." Okay, in the span of a minute, she torpedoed her entire argument. Her attorney saw it right away, but she didn't. They tried flailing around in the closing arguments, but it was all over, and I got more time with my children. Story 28, two high school kids spend their day each other off, so they decide to drive to a fast food restaurant to fight. They park, get out, immediately approach, and swing. Kid A connects the first blow squarely and solidity across Kid B and instantly drops him. The whole fight was one punch with a total elapsed time of few seconds. The restaurant is sued for failure to protect its patrons. The case is weak. Unfortunately, Kid B hit the pavement hard and had severe brain damage. Attempts were made to settle, but they were after millions. We knew walking, and they had two former employees testifying about large crowds building up after school. The plaintiff attorney aimed to prove the restaurant had a reasonable expectation of trouble and should have had armed guards in the parking lot. At best, their witnesses wildly exaggerating to the point of perjury. Their credibility was shaky in being highly disgruntled for being fired. We had a list of witnesses ready to refute their claims. At trial, the plaintiff attorney presented first. He spent a long time building up the bad blood between the kids, the serious damages of Kid B, and his potential earning capacity, a lot of foundation work to build sympathy for his client. We break for lunch on day 2, after which it would be the defense presentation. As we were talking through where we were and how we should proceed, we realized the restaurant was not really mentioned at all. Plaintiff held back his star witnesses to rebut the defense presentation the restaurant was safe. So when we reconvened, "Defense rests, Your Honor," the plaintiff attorney fell out of his chair. He begins frantically shuffling papers on his table and was stammering. The judge says, "I take it you will need a few minutes for your close." After that break, plaintiff's attorney gave one of the worst closing remarks I've ever heard. Jury, Kid B 10 at fault. Kid A 90 at fault. Restaurant 0. Story 29, obligatory, not a lawyer, but I was defending myself against a debt collector for a debt so old I could not even remember for sure that it was mine. Me to the debt collector, "Can you provide the actual contract bearing my signature along with a chain of title to the debt?" Debt collector's lawyer crickets. I look at the judge. Judge to lawyer, "Well, can you?" Debt collector's lawyer, while looking through paperwork, "Well, no. Not at this time, Your Honor." Judge, case dismissed. Note: to prove that a debt collector owns your debt, they must prove how it came to own it. Often, old debts are sold and resold over and over again to a number of subsequent debt buyers. When this happens, the debt collector must prove each and every assignment by showing a chain of title reaching all the way back in history to the original creditor. More often than not, for old debts, it is impossible for the collector to show this. Story 30, I was a second-year associate in handling my first trial. I represented the plaintiff. The defendant had an expert witness who had testified previously in about 40 similar cases. This expert came out to my client's property and did a completely bullshit examination of the issue, and his expert report was equally as bullshit. For those of you that don't know, expert testimony needs to meet a certain standard, the Daubert standard, at least in my state, in order to be admissible. This guy basically took some photos and put a ruler on the ground a few times to make his report seem legit. The partners at my firm told me it wasn't worth trying to file a Daubert motion to strike his report testimony because the case was low value, under $100K, and those types of motions can be very complex, and didn't want to build a client for it. I was so angry about this guy being deemed an expert that I came in on a weekend on my own time and drafted a 20-page motion to strike his testimony. I didn't bill the client a dime. The defendant didn't file a response to my Daubert motion to strike. Instead, they waited until right before the expert was set to testify. He had been sitting in court racking up fees for 2 full days beforehand. The judge had the jury leave the room, put the expert on the stand, and allowed the defendant to do a direct examination of their expert. The defendant's attorney, not taking my motion seriously, had their inexperienced associate just like me do the examination. It was incredibly basic and didn't respond to any of the points of my motion. I was in charge of doing his cross-exam. It was my first cross-exam of a witness ever. I tore the guy, a seasoned expert witness, apart on the stand. I got his entire testimony and report struck. They also had a second expert witness, who was pretty terrible, but not quite as terrible. I also did his cross-exam. Realizing that they were in serious trouble without their primary expert, and their second expert at risk of getting struck, the lead counsel for the defendant, a named partner at a well-known firm, did the direct exam for the second expert. I again did the cross. I got the second expert's testimony struck, except for one very, very tiny area. So essentially, he was forced to testify with both hands tied behind his back. It was the most gratifying moment of my legal career so far. Story 31, I witnessed this sitting in court. It was a drug case, and there was some discussion between the prosecutor, defense attorney, and the judge about the quantity. Judge says something like, right, but that's in ounces. How many grams is that? Prosecutor and defense attorney say they don't know. Judge says, we can figure out how many grams are in an ounce. Prosecutor and defense attorney still shrug, like to know. All of a sudden, the defendant pipes up, 28-3. Story 32. So I'm fighting a DWI case, and the cop is a lying liar who is telling big lies about what signs he saw on the field sobriety test, that my client was allegedly intoxicated. The state had not moved expeditiously enough to have a copy of all of the evidence in the case. So we got him up on the stand talking all about how my clients looked on the horizontal gaze and nystagmus test, then buried him with his own body camera footage, which he thought had been destroyed. It wasn't. The judge, the newly elected Democrat in Texas, made findings on the record that the police officer had intentionally lied and misrepresented the truth. The state still tried to fight the case, but it came out the right way.